So we have Richard Schwamm here in the office, the great, the powerful, the legendary Richard Schwamm. Tell everybody who you are and a little bit about himself.
Well, thanks, Eric. I appreciate you asking me to join you. My name is Richard Schwamm. I'm with the law firm of Haliczer, Pettis, and Schwamm. We have offices down in Fort Lauderdale, Orlando, boutique litigation firm, mostly handling medical malpractice cases, kind of a low volume of cases, high value practice.
So listen, I am thrilled to have him here because, how I always get reminded of you is that whenever I watch a CLE event, you're there. Like, you are a teacher, you're an instructor, you are a mentor to young lawyers. And so I wanted to talk to you because you are the master of technology. I love technology. How did you get into technology, I guess, in law? Like, what was the first thing that really made you really want to look into it?
Well, thanks for the compliment. I really appreciate it. So I got into law at a very young age. I went to Nova High School right here. And I was a shy kid, had a stutter, had a lisp, could barely get words out of my mouth, couldn't participate in class. Went to speech therapy for 8 years and still couldn't get past it until I finally taught myself how to stop stuttering, stop lisping, and then find my voice. So as I found my voice, I realized being a lawyer might be a really cool career path. So I joined a mock trial competition when I was in high school, and the moment I did that, I was hooked. So as I became a lawyer, and I realized a lot of younger lawyers might have followed a similar path, some challenges, some things that I might be able to help along the way. So I've really enjoyed mentoring young lawyers, and I've just evolved naturally into being curious about technology. Started with personal technology, and that slowly evolved to how can I use personal technology, mobile technology, and make my practice better.
Yeah, listen, what's funny is you brought up something, and it actually really rings true to me too, is I was terrified for public speaking. I never wanted to do public speaking. I hated it. And in law school, I forced myself to do it. I had to teach myself. And that's a perfect example of that. You don't have to be a natural. You could become a natural.
Right. A lot of it's about perseverance, right?
Yeah.
If you could overcome and truly persevere and succeed far beyond your wildest dreams and expectations, you got a little bit of moxie, you got a little bit of strut, you got a little bit of some confidence, then unless you try some new things. So I'm kind of a self-taught technology guy. I never took a class. I never majored in computer science or some sort of sound design or something like that. I was a guy that was curious about it and taught myself how to do it.
So, and what's interesting is there are things from what I hear when you give your lectures is there are things that you pick and choose that are in your arsenal that you like to use and that you don't like to use.
Right.
One of the things I know you like to use I want you to tell me, what are the things that you really like to use as far as in your litigation practice and trial practice?
Right. So I think about using technology, personal technology, mobile technology, office technology. I think about how do we use it in our private lives, personal lives. Everyone's got a phone. Everyone knows how to use it. Everyone's got a computer at home, knows how to use it. The question is going to be then, what can you use to make your practice better? So in litigation, obviously a smartphone, an iPhone, and all the apps. I probably purchased 600 apps over the years. I use about 8 of them. So I always tell people, if you want to know the best apps, call me, don't spend the money. I'll send you a short list, and you'll know the best apps you can use. So I find a way to use a mobile phone to help me stay connected to people. I find a way to use, in particular, iPads as a way of really making my practice more portable, more convenient for me. And I even use the iPad when I'm in the courtroom because there's great apps you can use there that'll help complement your practice and your presentation.
Yeah. So when I want to talk about a few of the apps, and it's funny because I'm always thinking there are a few that are out there that I would like to tweak or modify or make better. You know what I mean? So I'm a huge proponent of an app called Transcript Pad. Mm-hmm. I don't know if you ever used it before, but I stopped highlighting designations years ago. I used to highlight it. I used to give it to the paralegal. He used to have to type it up. And now I tap my finger on the thing. I hit a report. It creates it in 2 seconds, and boom.
Right.
It's really changed the way that I read depositions. Do you use stuff like that?
I do. So Transcript Pad is part of a suite of apps, as you know, and one of them is Trial Pad.
Yeah.
And in my view, when you find an app, you need to spend the time and learn how to use it, and don't run the risk of hopping from one app to another app. You got to spend some time and develop a relationship with that app and make it truly a part of your practice. So Transcript Pad is a wonderful example. Trial Pad is another example. Those are tools that literally make a task that would take you 6 or 7 hours to do. You're done in an hour and a half. And your staff appreciate you too, because they no longer have to type out your highlighted transcript the way they used to. It's already there for them.
Yeah, yeah. I have, and so when you go to trial, do you have a team, an internal team that you have, or do you hire outside people to help you with your in-court technology? When I go, depending on the type of trial, depending on the size of the case, how much money we're going to be spending on the case, we may outsource, bring in someone like legalese. Or recently, I tried a case and we got a great verdict in February in a medical malpractice case. And my co-counsel, we just downloaded a program and it worked seamlessly in the courtroom.
Right.
So, and we saved a bunch of money.
So each case is different, right? Certain cases really don't allow you to go out and hire the trial consultant, the trial technology team. That's going to be about $1,000 to $1,500 a day. If you've got an iPad, you put TrialPad on there. You can create your own Wi-Fi network in the courtroom that does not require you to access anybody else's Wi-Fi, which means it's solid. It's a great connection. And then you can present every document, every video, every photo on your TrialPad. I've tried a medical malpractice case using that up in the Panhandle, and like you, it worked seamlessly. It didn't cost me a dime.
Yeah, that's amazing. I've used TrialPad. I wasn't hugely into it. TranscriptPad is my big game. There's a program I want to introduce. I'll let you know about it if you don't know about it, but it's called OnQ. And there used to be something called Trial Director, and I think Trial Director may have morphed, and I don't know whether they're still out there. OnQ, you can actually purchase it just for like a month, like a 1 month subscription, then it goes away, but you keep the files on your system and you can purchase it later on. We used OnQ and it was so cool. I mean, you would just push the button and boom, the docket would come up, the call out would come up, and it would highlight, and then you'd be able to take it down real quick. You'd be able to play a video. I mean, right at your fingertips. Wow. Super fast.
So I've never used OnQ, but TrialPad does the exact same.
Same thing, no.
But whether it's OnQ, whether it's TrialPad, you have to spend the time with it. You've got to learn how to use it, see all the features, and then stay committed to it. Because I have now been introduced to OnQ. If I stop using TrialPad and jump to OnQ, I'm going to be behind the 8 ball when I'm not using TrialPad. So it's almost like it's a temptation to try what's shiny and new, although I am going to try OnQ. I'm feeling, though, that all of the apps that I use are ones that I've used for years and years and years because the people stand behind it, they keep improving it, they keep updating it, and it always works.
How do you feel about getting like a totally separate Wi-Fi to bring to court with you, like a hotspot?
So that's one option. I think it's an excellent idea. You can't rely on the courthouse Wi-Fi for a trial of a significant personal injury or medical malpractice case, because if it doesn't work, the judge gets impatient, the jury gets impatient. So I think having a hotspot's a great idea. If you use certain apps like a TrialPad, what you do is you bring TrialPad in, use an Apple TV. Any Apple TV generation 3rd or later allows you to create a closed Wi-Fi network, and you do not, I repeat, you do not need any Wi-Fi. You essentially have a Wi-Fi signal where everything works as long as you have a laptop or an iPad for all the equipment. And you can do things wirelessly.
So and I want to make sure that I'm clear about this. If you have an iPad and you have TranscriptPad or TrialPad on your iPad,
correct,
as long as you have an Apple TV,
correct,
and you connect it to, let's just say, a big monitor,
yes,
a TV monitor, do you need data to do that, or is it going to work without data?
Works without data.
Wow.
It doesn't cost you a dime.
Really?
So if you have all of your videos downloaded and you essentially have your portable trial on your laptop, you can use that, and then it will come up on the TV seamlessly. There's no lag. It's a control, essentially locked down network, and it's really, really easy to set up.
Is it wired or is this wireless?
It's the connection to your Apple TV is wired.
Okay.
But if you want, you can use your iPad, screen share, put it up on the screen as you're walking around the courtroom, question the witness.
So the iPad is going to connect to the Apple TV without a wire?
Correct.
Wow. So it is wireless. It's iPad wireless to Apple TV, which is connected to the TV.
Correct.
That's amazing.
It's a fabulous system.
So, and listen, whenever you go to trial, sometimes you're going to have difficulties with technology. How much do you rely on that in-court technology when you're trying a case?
So every trial is kind of a multimedia presentation, right? You've got to find a way to entertain the jury as you're describing your case and telling the story. So you're going to already have some multimedia to begin with. And so you might have some boards, especially when you're in closing arguments, you've got your verdict form you want to write on the board. You're going to have transcripts that are going to come up on the screen, maybe with video or without video. You're going to have medical records Maybe you have some of them on boards. Maybe you have some of them that are going to be on iPad. So it's always going to be a mixed presentation. The question is what if it all goes wrong? And what if your technology doesn't work? There's got to be a backup. Almost every courthouse has an Elmo. And for those folks that have never seen an Elmo, it's like one of those digital projectors where you can put a piece of paper on top of it, and then it gets broadcast on the screen. No Wi-Fi needed, no other technology needed. So you've got to have a paper copy of every document that's important. And then otherwise just go for it. Because 99 times out of 100, the technology works.
Yeah, 99 times, out of 100.
For sure. Just really worry about that one.
So when I think of the modern jury, I was always thinking to myself, we got to do more technology, more PowerPoints, incorporate more stuff. And then lately I've been thinking, maybe I got to slow it down a little bit. Maybe I got to go to that old school where I'm just using boards, maybe just a little bit of technology. Where are you at right now?
Right. So first, technology is cool, right?
Yeah.
Everybody enjoys it, new gadgets. And if technology can help you in the presentation of your case, it's important. Here's the challenge. You don't want to look too slick, right? We always worry what's going to be the jury's perception of us, because as trial lawyers, we know that our credibility is fundamental to the success of the case. If we don't have credibility, then they're not going to like our clients either and believe our case. So you really got to look at the makeup of the jury. There are times, and when I've got some jurors that are older who may be frustrated by their iPhones or even had to turn on their computers, maybe I want to alter my approach. You're right. A few more boards, we used to use jury notebooks where we would put an agreed upon set of the 10 most important exhibits, and everybody on the jury got a notebook with 10 tabs. And we would say, turn to tab 6. And collectively, the lawyers realized that was going to be the best way to present the case. So I think it really depends upon your jury, depends upon your case, and really it kind of depends upon your confidence level, because you don't want to overshoot. You don't want to assume the jury wants to be wowed when the simplicity of your case doesn't require you to do it.
See, when I was in law school and I was becoming a lawyer, I really wanted to become a great trial lawyer. And becoming a great trial lawyer, in my opinion, you have to learn from people who are great trial lawyers, who have been there, they've done these things. And when I'm sitting here and talking to you, it's, that you're sitting in the presence of someone great because you think about these things and you analyze, how is the presentation going to be so good? And you just mentioned something about juror notebooks, and it just got me thinking. I have never thought to myself, let's just put together a 10-page booklet for closing argument, and each juror gets that booklet, and let's talk to them. Let's take a look at page 1, guys, and then you talk to them a little bit about it, and then, you can put the notebook down, then explain a little bit more. Gosh, imagine that right in their hands.
Yeah.
I never even thought of it.
Well, think about it. The pressure on trial lawyers is great. It's an awesome responsibility to have the fate of a client's case in your hands. And we don't get to try that many cases, especially when you handle medical malpractice cases. So the thought is, okay, I don't get a chance to try a lot of cases. The stakes are high. I might represent a brain damaged child, or someone who's had an amputation, or a family of somebody who's passed away. With all that pressure, you feel like you need to put it all out there and wow them. And sometimes it's really just about telling the story.
Yeah.
I mean, I learned from some great trial lawyers. And what they said is, look, don't forget the story, because the story is what's going to win your case. The facts win the case. The story wins the case. The trial lawyer helps, but don't get away from the core of the story.
Yeah, and the core of the story, the themes of the story, and then what I was taught in the school of thought that I was in, and I went to the Jerry Spence Trial Lawyers College, and I learned from John Ustal and Bob Kelly, and other people like Joe Slamo was over at Krupnick Campbell. But what I learned from them was to bring the case to life.
Right.
To bring things into the courtroom. It's not going to just be me questioning a witness. It's going to be me interacting with the witness with some type of demonstrative exhibit or some piece of evidence, having him get off the witness stand and show the jury the evidence as opposed to just telling it.
Yeah, well, one of my mentors has always said, you need to find an analogy. And you need to kind of work your case around that analogy and find different places throughout the trial to keep coming back to that. One of the cases I first tried involved a retained foreign body. That's never supposed to happen. So you can think of 100 different things in life where that's a never event. Yeah. And the moment you can let a jury understand that there are lots of different never events, And that's one of them. They're already likely going to rule in your favor, but when you say things like never event, or you come up with an analogy that really rings true, and let's face it, we can do research on juries. We can find more about their personal stories, their presence on the internet, and sometimes in their trial, you're going to find a way to introduce an analogy or a metaphor or a story that's going to ring true for them.
Yeah, and that's powerful stuff.
Yeah.
That's powerful stuff. And I like that. A never event. It's a non-negotiable. Okay,
Right.
It doesn't happen. It's not that it's not supposed to happen. It doesn't happen. You know.
And everybody knows what that looks like.
Yeah.
You know, if you go in for a surgery on your finger tendon and you die,
Yeah.
the defense can say all they want. Well, you know, with anesthesia, that's a known complication.
Yeah.
No, I'm sorry. That's never supposed to happen. We always say that when the defense in a case raises the consent form defense.
Yeah.
Well, here's all of the risks and complications. I always like to point out on cross-examination when they ask our client, did you consent to this? I say, can you please show me the line on the consent form that says you consented to medical malpractice? It's not there.
It's not there.
It's never supposed to happen. Those are the cases that rarely go to trial unless you have an irresponsible defense lawyer or insurance company that won't do the right thing and try to resolve it.
And then what ends up happening is when there's an irresponsible defense attorney or insurance adjuster, you end up getting a big verdict.
Oh boy, we all know that nothing's worse for a defendant than an angry jury. And a plaintiff's lawyer's skill set includes the ability to do things that will make a jury not just understand your case, but wonder, why are they there? Why hasn't this case resolved before they got there? And if they find people blaming each other, we all know that's an aggravating factor. And if it's a never event, that's a multiplier on the verdict.
Yeah, yeah. So, I mean, listen, you have such a huge background and you worked on the defense side for years, right? Representing the defendant, which gives you such great insight to help the person on the other side, the plaintiff, the people that I always represent.
Right.
How was it making that switch from defense to plaintiff? How did you like that?
Well, for us, it was a gradual switch. We were one of the few firms in the state that we think were successful in both defending hospitals and doctors as well as handling cases on the side of the patient against hospitals and doctors. We did that for almost 17 years. And then finally, when we got to the point of switching sides completely and just became plaintiff's lawyers, it was liberating. Instead of having high volume of cases to defend, we now have a low volume of cases. We get to spend the time, the money, the resources, and all of our efforts helping those families that need our help the most.
And these medical malpractice cases, which is the core of your business,
It is.
Is there a threshold? Because when I take medical malpractice cases, we're very, very limited in the cases we take. If I screen 100 of them, I might take one, maybe a year, if that. And we don't get the call. We're not getting the same kind of calls potentially as your firm does. Is there a threshold? Because there is the cost, the analysis you have to make. Right. Florida law has its hoops you have to jump through. It's protecting the doctors, and so we have to look at these cases and say, are the damages significant enough for us to get involved? Even sometimes when it's clear liability.
Every firm that handles medical malpractice or catastrophic injury cases has a threshold. Sometimes it's not something spoken, but it's understood. Yeah. You know you're going to spend anywhere from $50,000 to $500,000 in costs. And the average length of time of a medical malpractice case is 2 years to 2.5 years. Yeah. So if you're going to handle a small volume of cases, you know that the damages need to be significant. So if it's a death case, typically you want at least one, if not three survivors from a family that's suffered the loss of a loved one, or a catastrophic loss case, a stroke, an amputation case. Those cases have significant future economic damages. Those are the cases we're drawn to. And very similarly to you, take about one every 110 cases we look at.
Yeah. Yeah. And you guys do a fantastic job. I mean, the reputation is, stellar reputation. You've grown that firm throughout the years. And so you're up in Orlando.
We are.
And you have offices in Fort Lauderdale. Are there any other offices in the state of Florida? Or it's Orlando and Florida, or Fort Lauderdale?
So we have an Orlando office, Fort Lauderdale office. Fort Lauderdale's always been home base.
Yeah.
Orlando's the second office that we have. We have nurses that work in our office, which is a luxury, a huge benefit that we can walk down the hallway, ask nurses to join a conference, go over the details of the case with the expert, the details with us, do the medical literature research. Not a lot of firms have nurses that actually work in the office. Huge plus for us. And I think if we looked at our partnership level collectively, I think we have more than 200 years of experience litigating complex cases and medical malpractice cases. We know that that's something that very few firms are able to compete with.
And you know what it is when I think of you guys, and when it's something that I think is important for any person who's looking for a lawyer. Like, I look at you guys and I say to myself, if something were to happen to my family, right, a medical malpractice, those are the types of lawyers I want involved. And that's a huge compliment. I'm telling you, like, I think of like other people, like people that I've worked at Kelly Ustall or wherever, and I say to myself, that's, if something happened to someone that I know, that's the person I want looking at my case, jumping in, helping out, representing me, which is, I mean, I think that's what we all strive for. I hope that people look at me and say the same thing.
I think
hopefully I aspire to get there one day, you know?
I think they do. Look, integrity is the cornerstone of every lawyer's practice, right? And our reputation. I mean, there's nothing you can do to repair a reputation once it's been harmed. When we decided to do plaintiff work, my very first client ever handling a medical malpractice case is I represented a risk manager of a hospital.
Wow.
The second client was a CEO of a hospital. So when your clients that you've represented defending medical malpractice cases entrust you to help their families, it's very rewarding, and thankfully that momentum's continued.
Yeah, that's always one of the biggest compliments, is when you have litigated a case against someone and that lawyer on the other side, and in this instance, it happened to be the actual CEOs, the actual executives, but when you've litigated a case on the other side, they come to you.
Right.
You know, or you've represented them, they come to you.
Yeah, there's probably some corny commercial for some product out there that there's no greater compliment than when the other side recommends you to a friend.
Right.
I'm sure there's some product out there, but really, when your colleagues in the community, and you know how close a community our legal community is, when people have something horrible happen in their families and they're reaching out to you for help, there's probably no greater compliment. It's one thing to have somebody within the public or within the community that looks for a lawyer and needs some help. But when lawyers that know better and they know who the best are and they're the ones that are reaching out to you, you're right. That's very rewarding.
It's a great feeling. It's a great feeling. All right, let's change topics. I want to talk about young lawyers, mentoring young lawyers. You know, we were talking about that there is a different climate right now in the work environment for young lawyers. What is like the biggest piece of advice that you would give like that young associate they just passed the bar, they just got hired at the law firm? What would it be to achieve success in the legal career?
Sure. So I've been practicing 32 years now. And when I started practicing, it was all about the grind. 70 to 75 hours a week was not unheard of. That's what we did. I got to the office on Saturday morning at 6:15 because my boss got there at 6:30. And that was the grind year after year, literally decade after decade. So when I talk to young lawyers and they talk about, you know, I'd like a hybrid environment, sometime at home, sometime at work. I need some control over my schedule. I need work-life balance. I tell them to just pause for a moment and say, are you grinding? Are you doing enough to separate yourself from all of the other lawyers out there that you're competing with? Are you finding a way to make yourself indispensable? That is what makes a great associate, what makes a great future junior partner, and one day might make a great senior partner. So I often tell lawyers, stop acting so entitled, stop acting like you're the one who should be making the decisions, and just grind and work hard and keep your nose down.
And it's not easy to find that person. And I was that young associate. I wanted to do personal injury so bad and become a trial lawyer so bad that as soon as I got my foot in the door, I was there first thing in the morning. I was there late at night grinding. And I think that is the way. You put your head down, put your blinders on. Don't worry about what the person to your left or right is doing. Get out there and work hard. Okay, and you're going to sacrifice. I mean, I sacrificed for very long, and I'm still sacrificing, but I sacrificed as a younger lawyer for a very long time. But I don't think I would have achieved the level of success without doing that, you know?
What really helps is if you've got a passion for the job, while it's work and it's tiresome and it's a grind, you love it, right?
Yeah.
I love being a trial lawyer. I can't imagine doing anything else. But when you see lawyers that are looking for escape clauses of, well, I really can't do this, or I don't want to do that, or I really wish I was doing this, they probably don't have the same level of passion, and they're never going to be great. You cannot create passion in someone's heart and someone's mind to succeed. But when you find those people that have that passion, that have that perseverance, that have that work ethic, those are the folks I love to mentor because they're receptive and they get it.
Yeah, and they're willing to put the time in to achieve greatness, and because you know what other people don't realize is you got to put that. There's no quick way to becoming rich or to becoming successful. There's no fast track. There's a couple unicorns out there, these social media influencers that are out there talking about you can make money, this and that, blah blah blah, and all you got to do is 30 days. It's all lies.
Right.
Okay. If you really dig into some of those people, some of the actual influencers, and maybe they're putting a lot of time in. They're putting a lot of time in. There's no shortcut to that success. You got to build the foundation, become an expert in your field, which you've done, or which I've done, is become an expert in that very niche area, whatever it is, and then eventually you'll see the results.
I agree with you, because everybody has a different definition of hard work. But when I grew up, I watched my dad work hard. He traveled a lot. We used to have a plate for him at the dinner table, and sometimes we would put his picture on it because Dad was out working hard for us as a family. My kids see that same thing in me. Now I'm out a few more years where I've got a little bit more flexibility, but it's not uncommon at 10:30, 11:30, midnight, my kids stumble down from being awoken by something and they see me in the office.
Yeah.
And I'm not doing it to impress anybody. The work requires the work. And if you're not willing to put in the work, don't complain that you're not getting the level of success you want.
Yeah. Yeah. That's amazing. I mean, I'm so thrilled that I was able to get you in here to talk about all these different things, technology, mentoring, law students, and all the other great stuff. And your firm is just doing fantastic. Listen, I really appreciate you coming in here
You bet.
and chatting, because like I said, we got a titan of the legal industry who, like I said, I'm reminded of you every time an advanced medical malpractice seminar is on. I see you there. You're talking about technology. You're sharing. You're helping out. And you know what the best part about that stuff is you're not getting paid for it.
No.
You are doing it to help. And maybe one day one of those people in the crowd, they're all competitors, and you know what I mean? But maybe one day they're going to reach out and say, you know what? Hey, Schwamm knows his stuff. Let's give him a call. I need help. You know what I mean? And that's, it's doing the right thing, helping other people. And eventually it may or may not come back, but it's all good.
Well,
right?
Whether it's working hard as a young lawyer or figuring out how to use technology, a lot of what we do and why we do it is we really enjoy building relationships. You have succeeded probably even beyond your own expectations of building relationships, starting your own firm, doing things that very few people have the guts to do. But the building relationship piece, in my view, is one of the most fun parts about being a lawyer.
Yeah, it is. Well, listen, I appreciate you coming in. This was fantastic. Thank you so much.
Thanks. Appreciate it. Thanks, Eric.